Be ready. 5 seconds. Start. In order to support his case, the accused petitioner took a risk by stepping himself into the witness box and offered himself for cross examination. Stop. He asserted in his cross examination that the tax return was deposited in cash and the complainant used to take cash from him. Stop. His version was also supported by one Parveen Kumar DW2. Stop. From the above noted discussions, it is clear that the parties were in fiduciary relationship and heavy burden was on the complainant to prove that he had advanced a loan of rupees 15 lakhs to his client without obtaining any writing and that he has not misused any blank check of his client. Stop. Such loan was not shown in the income tax return of the complainant. Stop. For the reasons mentioned above, the case of the complainant becomes highly doubtful and is not beyond all reasonable doubts. Stop. Therefore, no presumption under section 138 of the Negotiable Instruments Act 1881 can be raised. Stop. Both the courts below erred in holding the accused petitioner guilty for the commission of offence punishable under section 138 of the Negotiable Instruments Act 1881. Stop. In view of the foregoing discussions, CRR number 849 of 2016 is allowed and CRR number 2017 of 2016 is dismissed. Stop. The accused petitioner stands acquitted of the notice of accusation served upon him. Stop. The short question before us is whether the High Court was right in reversing the concurrent factual findings of the trial court and of the appellate court in exercise of its revisional jurisdiction. Stop. The questions of law which rise in this appeal are whether a revisional court can, in exercise of its discretionary jurisdiction, interfere with an order of conviction in the absence of any jurisdictional error or error of law, and whether the payee of a check is disentitled to the benefit of the presumption under section 139 of the Negotiable Instruments Act of a check duly drawn having been issued in discharge of a debt or other liability only because he is in a fiduciary relationship with the person who has drawn the check. Para. The trial court, on analysis of the evidence adduced by the respective parties, arrived at the factual finding that the respondent accused had duly issued the check in question for rupees 15 lakhs in favor of the appellant complainant in discharge of a debt or liability. The check was presented to the bank for payment within the period of its validity, but the check had been returned unpaid for want of sufficient funds in the account of the respondent accused in the bank on which the check was drawn. Stop. Statutory notice of dishonor was duly issued to which there was no response from the respondent accused. Stop. The appellate court affirmed the aforesaid factual findings. Stop. The trial court and the appellate court arrived at the specific concurrent factual finding that the check had admittedly been signed by the respondent accused. Stop. The trial court and the appellate court rejected the plea of the respondent accused that the appellant complainant had misused a blank signed check made over by the respondent accused to the appellant complainant for deposit of income tax in view of the admission of the respondent accused that taxes were paid in cash, for which the appellant complainant used to take payment from the respondent in cash stock.